G'day. You'd think that selling a management rights business should be a lot easier than when you bought one. And unfortunately, it's not necessarily the case. So we put together this video for you to explain probably in a little bit more detail and run in parallel with the guide that we published for people selling management rights businesses to give you more information about what happens, how the process works, where some of the pitfalls are, and hopefully that will allow you to avoid some of the common mistakes that people make when they're selling their business. But it certainly starts with being prepared, because you've got plenty of time to do that. So I hope you enjoy this. One of the very big differences between selling a management rights business and buying one is that the preparation from a sale perspective is well and truly within your control. When you're buying one, you're scouting around, you're trying to find areas, types of businesses, units that you like, deal with agents you like, figures that fit where you sit from a financing perspective and all that sort of stuff, and the market can be enormous. From a sale perspective, you know what it is you're selling. You've just got to be prepared. And from our perspective, one of the really big things we see is troubles on deals when our clients as sellers haven't quite organised themselves the way they should be before they've actually listed the business. And in no particular order, that includes making sure that your figures have been done by your accountant and are right, because nothing annoys a buyer more than when the figures are wrong. Making sure that your agreements are topped up to the greatest possible degree, options are being exercised, gallery V is being dealt with. Making sure that if you've got any issues with your body corporate, that they're disclosed up front and dealt with, or otherwise put to bed before you actually go to sell. And making sure that all of your letting appointments are squeaky clean. So they're not on old forms, they're not without assignment clauses, that the commission rates match what it is you're actually charging, and so on. Because one of the things that will be guaranteed in a sale is that the buyer's advisors and the buyer themselves are going to go through your books and records. They're going to look at your letting appointments. They're going to review your agreements. They're going to review the body corporate records, so that if those things aren't where they should be and you haven't managed the buyer around that as part of the sales process, then that's where the troubles start. So that first thing is to be really, really organised. Make sure you know what it is you're selling, and be ready for buyers to ask the questions to which you've got the answers. The process for agreeing terms on your management rights sale is the reverse of what it was when you bought it. Ultimately, you're probably setting a price for your unit, if you've got one, for the business, that's guided by either valuation advice or your broker. They're certainly the people to talk to. And it's not uncommon for people to ask a little bit more than what it is that they actually expect to end up getting. But the offer and acceptance process is the same. Usually, buyer will make an offer, you will counter, you'll go backwards and forwards as often as needed to the extent that you can actually reach agreement. And then there'll be a one-page document that most people will sign that isn't legally binding, but does give each of the other sides confirmation or assurance that the other party is committed to the deal. After that, we actually then need to do contracts. So some brokers prepare contracts, but most are now leaving them with the lawyers. So the contracts are not dissimilar to what it is when you bought. Again, contract for the unit, if there's a unit involved, contract for the business with the standard management rights conditions that deal with all of the terms that might be specific to your deal. And the other thing that has changed in recent times is that there's a new disclosure regime for property sales in Queensland. So that is much more, for want of a better phrase, horrendous on the part of vendors in terms of making sure that all of the information around the property is disclosed. So if you're serious about selling and there's a piece of real estate involved, it sometimes can pay to get your ducks in a row with respect to that before you actually go to contract, rather than wait the week or so and get the necessary searches afterwards. Again, if you're selling a unit, there's also the same body corporate disclosure that's always been there. That's been beefed up a little bit, but the body corporate management companies will generally provide that. So there is a bit of paperwork to come after you've done that initial one-pager. But again, in the right hands, all of that's manageable. You've just got to allow potentially a little bit longer if you haven't got your ducks in a row and prepared it beforehand. Once the contracts have been signed, the clock starts ticking on the buyer's due diligence. Now, that due diligence can really encompass three things that are usual. The first is a verification of figures, the second is a legal due diligence, and the third is finance approval. All of those elements are within the buyer's control. So the way the standard contract works is that if the buyer decides that any of those conditions aren't to their satisfaction, they terminate, they get their deposit back, and they walk away. No ability to recover costs, it's all over. So from a figures perspective, their accountant will normally send you a request asking for a whole bunch of ledgers and information and books and records. They might come on site and do an inspection of all of the letting appointments and so on. And interestingly, it depends whether you're in North Queensland or otherwise. In North Queensland, the accountants tend to leave the letting appointments to be reviewed by the lawyers. Everywhere else, they're reviewed by the accountants. But again, we'll just work that through as we go. But either way, the accountant wants to be able to confirm to their client as buyer that what you've told them the business is making, it is actually making. So that's their fundamental job. And again, hopefully you got that when you purchase, so you've got to expect that on the other side. So if you haven't prepared properly and your figures might be 6 months out of date and you've lost 3 units from the rental pool and haven't adjusted that, or there's letting appointments missing, all of that is then going to come out in the figures. And there'll be a negotiation more than likely off the back end of that. So figures at this stage are normally running at about 21 days from the date of the contract. And once that box is ticked, we move into legal due diligence. That's normally another week or two after figures. And that's where the buyer goes through, or the buyer's lawyer, all of the management rights agreements, body corporate records, CMS, survey plans, intellectual property reports, and everything else that goes into making those agreements valid. And that's where ultimately, if we've acted for you on the purchase, our work will be tested on the way out. So main thing with these things is that obviously, hopefully the job was done right when you bought, but if there's any body corporate issues that are lurking around that haven't been disclosed, this is the stage where those will be asked for. So for example, if as a seller, you've got 5 breach notices issued to you over the last 12 months, that's something that is going to come up in the body corporate records inspection and should be something you let the buyer know about before they sign the contract or as part of the contract process. Because if you put yourself in the buyer's shoes and you're doing a due diligence and it turns out that the vendor has been breached by the body corporate 5 times, would you be happy that the first time you knew about it was when you saw the breach notices? Or would you want to know about it beforehand? I don't know the answer to what I would be saying. So once we get past that legal due diligence process, we move into finance approval. That's normally running parallel with the verification of figures because banks still will usually lend based on the income from the business. So they need to see the report. They can then plug that into their matrix and make sure that with serviceability and borrowing and all the other bits and pieces that the buyer's got the ability to service the loan. So that's normally probably a 3 or so week process past figures. So that buyer due diligence, we're saying to clients now from a sales perspective, is somewhere from 6 to 8 weeks. And that's the reality of it. Things are moving with a bit more detail than usual, and it's pretty uncommon for those to go through completely seamlessly. Normally there'll be an extension or a negotiation or question somewhere along the way. It might even be that the buyer gets a valuation as part of their finance approval and the valuer doesn't like the multiplier. Whatever it is, it's a matter of step by step. There is an end game there. You've got to roll with the punches when they arrive, knowing that basically if anything makes the buyer unhappy, they have got the right to terminate. So this is the stage where you've got to be a bit careful with how you respond. And ideally, if you've got the right broker on board, they can help negotiate any of these difficulties that pop their heads up, because negotiating through lawyers is particularly difficult because we can't talk to the other side. All we can do is communicate to the lawyer who then communicates to their client, and it comes back to us and goes backwards and forwards that way. A broker that can pick up the phone and get on the phone to the buyer, have a conversation, come back to you and sort stuff out is a much better way to go. And of course, if you don't have a broker, you might have to do it yourself. So it's completely up to you. But those steps are fundamental and haven't changed, certainly in my 30 years in the management rights industry, and I can't see them changing anytime soon. So having the right hands to guide you through difficulties in this step is really important. Usually after the contract is unconditional with respect to things within the buyer's control, we move on to the body corporate approval process. Now, I should point out that that doesn't have to wait until the buyer's unconditional. It can happen before they're unconditional, but at that stage, you're probably triggering the body corporate and asking them to get involved when the buyer might still walk away. Although, if you're in the unfortunate position as a seller where your relationship with the body corporate is difficult, it might even be that you've introduced the buyer to the committee before you've even started the process. And again, we can guide you around that as we get there. But from a body corporate approval perspective, there's two things. Firstly, there's the legislation, which is very prescriptive. Body corporate's got to make a decision within 30 days of getting all of the information reasonably necessary to consider the assignment. So that's references, resumes, buyers' material that addresses their competence, their qualifications and their experience, and importantly, their financial standing as well. And the training that they're going to get under the contract, which would normally be 7 days before and after. So all of that needs to go to the body corporate. Sometimes there's additional provisions in your agreement you need to deal with. And then we move into probably what is the most variable part of the whole sales transaction, which is the body corporate committee approval. Each committee is driven by its own personalities and also in part by the body corporate manager that has been engaged. So the committee might want the full third degree. They might want to engage a third party to help assist them in reviewing the buyer's material and to make sure that they've asked all the questions they should be asking. If your relationship with the committee is rock star and they love you, they might not even want to meet the buyer and simply wave it through, although that's getting less likely these days. A body corporate will also likely go and get their own lawyer to review the documents that the buyers are asking them to sign in relation to the assignment. And that's a legitimate question or a legitimate step to take because they're being asked to enter into a legal transaction and they're entitled to know what it actually means. And unfortunately, as a seller, you're going to bear the costs of that because the only reason the body corporate's been asked to do that is because you've sold the business. So this part of the process is the most variable, and it's also important to take into account the time of year you're actually asking it. So if you're asking the committee to consent to an assignment in, say, the middle of December or early April, you're going to bump into Christmas and Easter. And that is a time when lots of people go on holidays, and that's going to slow it down. And as much as a body corporate committee can't unreasonably withhold consent to an assignment, it doesn't mean they can't be bloody difficult if they want to be. And that's the reality of it. So again, this is testing the temperature of your relationship with the committee. If you get on famously with them, then asking them for favors to move an assignment through probably is going to be okay. If, again, you've been subject to breach notices and been arguing with them about performance of duties and they've been unhappy for the last 12 months, then unfortunately you can expect the committee to reply in kind at this stage. And where we need to be careful from a lawyer's perspective is to make sure that the buyer doesn't become the meat in a bit of a revenge sandwich where they're trying to square up with you and take it out on the buyer. But by the same token, the buyer, hopefully from their due diligence, would expect to be a little bit ready for questions from the committee about performance if there's been issues with you. So again, this is part of the moving parts that come with a management rights sale. And at this stage, particularly if you've got a full committee of 7 and they're active, you've sometimes got to herd the cats. And that's part of our job, part of your job. And it's also part of the experience to know what you need to do and when, and where things might get off the rails. So again, it's testing the temperature of the room, making sure that you dot the I's and cross the T's in terms of doing what you have to do with the committee. And hopefully from there, you've just got to take it step by step. So now we come to settlement. We're through all of the buyer's conditions. Hopefully we've got body corporate approval without any issues. And what needs to happen now is we need to bring the parties together. So on the one hand, you hand over all the documents that constitute the management rights business and title to your lot. In exchange for that, you get the balance purchase price that you've agreed. So from a settlement perspective, we'll certainly do all of the adjustments between the business and the unit for levies, for the caretaking remuneration and so on and so forth. What you need to do is make sure that you've got the adjustments between yourselves from a business operational perspective on the ground. And that might be payment for bookings or lettings in advance of settlement and before settlement, and other little business type adjustments from software rental or otherwise that need to be done on the ground. So quite often you might get a bookkeeper involved in helping you with this, and the software companies will come in and do changeover training as well to make sure that everyone's up and running on their system. And ideally, that 7 days before settlement training that most contracts have, you'll be talking to the buyer about this to make sure that everything's happening the way it should be. One of the things that we try not to recommend to clients is to have body corporate approval and settlement happen on the same day, because unfortunately, we still live in a wet ink world with management rights where we need original signed copies of documents. Now, body corporate seals are gone, but we still need signatures on documents. That is wet ink, and on those we're going to have the buyer, any guarantors, you as seller, and a couple of committee members. So signing stuff in the morning and settling in the afternoon and making sure everything is where it needs to be can be a difficult process. So ideally, and the standard management rights contract provides for this, is that settlement's usually 5 business days after body corporate approval. We can sometimes accelerate that, but as you'd know, trying to organise getting out of a house and or a unit, you're certainly got to be closing things down and moving and cleaning, do all that sort of stuff. It takes time. So we will bring it all together, but it's important to make sure there's enough time to make sure all of the moving parts can be where they need to be at the right time on the right day. So hopefully that will be helpful to you in selling your management rights business. Now, clearly there's a lot more that can go on in any sales. So I'd encourage you to read the guide, because we talk about a lot more stuff in there than what I've covered in this video. And probably for me, you'd think this stuff should be simple, but it's not. There are a lot of moving parts. And I think for me, one of the things that experience gives you, and having been around for a long time, you just can sense when things are going off the rails. You can sense when they're going off the rails from a condition perspective, where the buyer's running quiet. They might be asking questions that are a bit random. The body corporate manager might be going a bit quiet. Your committee might be acting differently to what they should be. Maybe the body corporate lawyer's asking for some stuff that isn't necessarily standard. And ultimately, that's where experience in dealing with these things through a couple of decades comes to the fore, because quite often we can cut those off at the pass. So again, if you need any help on your sale, let us know.